Hello everyone, I welcome you all to the first episode of this new series under M&A Transactions. In this series, we'll be talking about the transaction documents. So, when we talk about M&A, there can be different transactions under the head of M&A. It could be a merger, it could be a demerger, slump sale, asset sale, and the most common is acquisition of shares. So for the purpose of this series, we are going to focus only on the acquisition of shares transactions. And therefore, we'll be discussing shareholders agreement. The reason why we are choosing this mode of M&A because the focus of this series is on final year students or young professionals who have just started their career. Starting with what is a shareholders agreement? A shareholders agreement or an SHA is an agreement between the shareholders of the company. As the name suggests, and it deals with the inter se rights and obligation of shareholders in the company, and it also deals with the matters relating to management and operation of the company. It deals with the corporate governance provisions such as board meetings, shareholders meeting, how meetings will be conducted, how notices will be given, and things like that. And it also deals with the share transfer restriction because we are talking about the private company. So in private company, as you all know, private companies can have share transfer restriction. Their shares are not freely transferable as the shares of a public company or a listed company. Shareholders agreement are generally coupled with either SSA or SPA. SSA means share subscription agreement, where new shares are being issued to the investor, and SPA means share purchase agreement, where existing shares are being acquired by the investor. So before while we are drafting an SHA or negotiating an SHA, we need to keep few things in our mind in case we are negotiating or drafting SHA for investor. Then we need to see whether the SHA has enough provision with respect to protection of investment or the protection of amount being invested. There restriction on unnecessary cash burn by way of approval of a business plan, and are there enough provision with respect to keeping a check on the affairs of the company by way of board seat and affirmative vote matters? Are there any provision with respect to protection against promoters running away from the company in the form of either lock-in of shares, non-compete restriction, and share transfer restriction on the shares of the promoter? And is there are there any provision with respect to assured return in the form of a liquidity preference, and whether the company and promoter are agreeing on providing exit to the investor either by way of IPO, third party sale, buyback, drag right, etc. And similarly, from the point of view of promoter, we need to see whether promoter is losing control of the company and this investment round by way of either dilution of their equity or by way of dilution of their board representation. Are there any uncapped liability that a company or promoter is agreeing with the investor? Are there any unrealistic targets being set in the SHA which promoters will not be able to achieve? And are there any unrealistic or unnecessary long lock-in on the shares of the promoters? And protection whether the employment of promoters as CEO, CTO, or CEOs is protected or not? Are there any non-compete clause or non-solicit clause? And most importantly, promoters need to see whether they will have enough freedom to run their business as the way they want without much interference from the investor and investor directors. And the second thing which promoters need to see that which they need to keep in their mind, that this is not the last round of investment. This could be the first or very first round of investment, and there'll be multiple rounds of investment, and multiple or different investors will come in the company. So they should be very conservative when it comes to giving away their rights or giving preferential treatment to investor, because that sets an informal benchmark for the future investor. Any future investor which will come in company in future will not or may not agree on the terms which are inferior to the terms which were given to the earlier investor. Therefore, these things have to be keep in mind while negotiating or drafting any SHA. from the promoter side. And and while deciding whether the promoters want to give away their right or want to give some special right to investor, they need to focus on the percentage of equity or percentage of shareholding that an investor will get from the investment in the company. They should not look at the amount, but at the percentage. This is the only way or through which they can measure this. There is no mathematical formula and there is no watertight mechanism to decide as to when and what they need to give up. So first thing we'll discuss today is the concept of execution date and concept of completion or closing date. Execution date means the date on which transaction documents are being executed or signed by the parties, and closing and completion date means when the transaction that is contemplated in the mentioned in the transaction document gets completed, as in the shares are being allotted to the investor and investor has invested in the company. And why these two dates are different and why there's a gap? Because to undertake or to complete the transaction, there are certain prerequisites that will have to be fulfilled before a transaction can be completed or closed. Mostly it's on the part of promoters and company that they need to do all the prerequisites. These are called conditions precedent. So there can be a few examples. I can quote for condition precedent, such as regulatory approval. Regulatory approval for investment in the company. So if investor is investing through government route, then a regulatory approval will be required for such investment. So that regulatory approval becomes a conditions precedent. And execution of any other document such as employment agreement of CEO, COO, CTO, and increase in authorized share capital. Suppose the company doesn't have enough authorized share capital to issue new shares, then authorized share capital has to be increased. So this will also become a condition precedent. Agreement on the restated SHA, or sorry, restated AOA or amendment in AOA, because as as we discussed that SHA also talks about the management and operation of company, or provisions relating to management and operation of the company. Therefore, the provisions of or clauses of SHA are included in the AOA of the company, which is the constitution of the company. So amendment of AOA is approved on the date of closing, but the draft amendment that will be put before the shareholders for their approval is agreed as a part of conditions precedent. And then comes the condition subsequent, that happens after the closing. So once the conditions precedent are fulfilled, a party will issue a certificate, as in the promoters and company will issue a letter to investor informing that they have completed all the conditions precedent, and if investor is satisfied with the conditions precedent, then it will issue a certificate of satisfaction of condition precedent, and then parties will move towards the closing of the transaction, and then investor will invest in the company, and company will allot shares, and whether if investor is getting a board seat, then the directors of the investor will be appointed on the closing day. And so and to complete these conditions precedent, parties also agree on a timeline. It could be 15 days, 30 days, or even more, based on the nature of the condition to be fulfilled. So this brings us to the next part, that is standstill provision. These provisions are applicable from the date of execution till the date of closing. Generally, these provisions are put in the SHA just to protect the interest of investor from the date of execution till the date of closing, because investor has taken a considerate decision to invest in the company based on the financial due diligence and legal due diligence reports and other commercial considerations. But within the date of execution till the date of closing, there can be material change in the financial position of the company, or there can be material commercial change in the company which may not be favorable to investor, then and therefore there are standstill provision in the SHA. And what these provision deal with, generally it restricts certain actions from the company and promoters, such as it requires promoters and company to run to undertake business in the ordinary course, not to do anything which is out of ordinary, and they should not take any action which has material adverse effect on the upcoming investment and the business of the company. There should not be any say adverse change in the financial position of the company, say by taking a large or big quantity of loan, or creating an encumbrance on the assets of the company, or declaring dividend in the company, or change, amending or terminating any material contract of the company. So these are the restrictions, I mean these are the generic restrictions which you will find in any of the standstill provision, but there can be other specific standstill provision based on the nature of the company and nature of the business. The While agreeing on the standstill provision, promoters need to uh, clearly see if there is a likelihood or probability of these provisions being violated by the company or promoter. Then, in that case, they need to create specific exemptions or carve outs for such transactions which they foresee that can happen before the closing date. Suppose they are also discussing amendments in the one of the material contract, and which they foresee that it will be completed before the closing date. Then for such material contract they will have to create an exemption in the standstill provision. If they foresee that within 120 days or 60 days, whatever the time of completion of CP uh, is given, conditions precedent is given, then and they feel that they will be taking a loan from one of the lenders, then either they can agree on a specific loan or they can agree on a limit that company should be allowed to take loan up to a certain amount based on the nature of the business and size of the company. So that's how standstill provision will work for promoters and investors. And with this, we come to the end of this episode, and we have discussed the provisions with respect to execute from the date of execution till the date of closing. In our upcoming videos, we will be discussing provision which will take effect from the date of closing. That will be your provisions related to board meeting, shareholder meeting, and affirmative voting right if an investor is getting any, and your share transfer restrictions such as ROFR, ROFO, tag along, preemption rights on the securities of the company, and provisions related to exit of investor by way of IPO, buyback, third party sale, trade sale, or provisions related to liquidity preference, anti-dilution protection, and provisions related to non-compete and non-solicit on the promoters and founders of the company, and dispute resolution, and indemnities. If any indemnity is given by the company and promoters, then these provisions will also be captured in the. Thank you very much for watching this video.